with American troops facing the enemy on the field of battle, I would not be living up to my oath of office if I failed to do whatever is required to provide them with weapons and ammunition they need for their survival. Therefore, I am taking two actions. First, I am directing the Secretary of Commerce to take possession of the steel mills and to keep them operating.
The issue in this story is the power of the president and its limits. Not often is the president's authority directly attacked in a lawsuit, but that is what happened in the administration of Harry S. Truman in the second year of the Korean War, when he ordered the federal government to seize the major steel mills of the United States. The legality of that action, debated with intense feeling, was finally resolved by the United States Supreme Court. This is the story of its ruling and the conflict that led to it. The story of a president's power contested. The Korean War began in June of 1950, when troops from communist North Korea marched into South Korea. The United States acted swiftly. President Truman sent American forces under General MacArthur to the aid of South Korea. At the same time, the president submitted the dispute to the United Nations. The United Nations made the war its own, entrusting the command to the United States. From then on, it was a United Nations army that fought in Korea. This army came to include units from many lands, but its weapons and ammunition had to come mainly from American mills. To deal with the strike, President Truman had a choice of two procedures. One was the use of the Wage Stabilization Board, which he himself had set up. The other was the Taft-Hartley Act. Under Taft-Hartley, the president could obtain an injunction against the union, forbidding a strike for 80 days, while efforts were made to find a settlement. If, after 80 days, no settlement was reached, the strike could go forward. In Congress, the president was being urged to use the Taft-Hartley Act. But Taft-Hartley was anathema to organized labor, and the president himself had always opposed it. It had been passed in 1947 over his veto.
Criticized and attacked by him. It is difficult and dangerous to work out great public problems without the slightest cooperation from a hostile president. The only way this fundamental difference can be resolved.
His upset victory over Thomas Dewey in the 1948 presidential elections was due, in part, to labor's appreciation of the president's attitude toward Taft-Hartley. Now, since use of this law was optional, the president chose not to use it. Instead, he personally requested the union to postpone the strike, while he referred the dispute to the Wage Stabilization Board. The union agreed. Production continued. Twice more, while the board studied the case, the union postponed its strike. Finally, late in March, the board made its report. The board said the raises were in line with its established policies, permitting raises up to 10%. The board's recommendations were supported by its public members and labor members, not by its industry members. The United Steelworkers accepted the proposal. The companies rejected it. They said the proposed wages would require an increase of at least $12 a ton in the price of steel. The union set a new strike deadline. The industry, preparing for a shutdown, began to cool its furnaces. Behind the scenes, the administration made feverish efforts to secure an agreement on terms that included a more limited price increase. Then, on April 8, 2 hours before the strike deadline, President Truman addressed the nation.
The steel companies and the steel workers down here to Washington at the earliest possible date in a renewed effort to get them to settle their dispute. The plain fact is, though most people don't realize it, the steel industry has never been so profitable as it is today, at least not since the profiteering days of World War I. And yet, in the face of these facts, the steel companies are now saying they ought to have a price increase of $12 a ton, giving them a profit of $26 or $27 a ton. That's about the most outrageous thing I ever heard of. They not only want to raise their prices to cover any wage increase, they want to double their money on the deal.
The federal government took possession of the steel mills. These raised the American flag and continued production under their regular managers. The president sent a message to Congress inviting it to follow his action with appropriate legislation. Possibly, he suggested, legislation confirming the seizure and setting terms and conditions. Meanwhile, the companies struck back through court action and through radio, film, and press. Clarence Randall, president of Inland Steel, made a statement.
Where a private citizen may look the president in the eye and tell him he was wrong. But actually, it is not the President of the United States to whom I make answer. It is Harry S. Truman, the man who last night so far transgressed his oath of office, so far abused the power which is temporarily his, that he must now stand and take it. A sad chapter has been written in American history which must be erased.
Action continued on a multiplying variety of fronts.
The companies believe that free and fair collective bargaining on both sides can bring this unnecessary and untimely strike to a quick end. They are ready to
Collective
proceed.
bargaining was resumed, and the steel companies made their first offer to the union. It was rejected. At the same time, the companies sought court injunctions to halt the government seizure. These were nominally directed against Charles Sawyer, the Secretary of Commerce, but in effect they were a challenge to presidential power. Government lawyers prepared their defense. They based authority for the president's action mainly on Article 2, Section 1 of the Constitution. The executive power shall be vested in a president of the United States of America. They argued that the powers inherent in the executive, particularly at a time of national peril, justified the president's action. Early in the Civil War, President Lincoln, on the basis of his emergency powers, ordered seizure of the rail and telegraph lines between Washington and Annapolis, without authorization of any specific law. Months later, Congress passed a law confirming the president's right to seize railroads and telegraph lines and providing penalties for interference. Early in the Second World War, even before Pearl Harbor, President Franklin Roosevelt ordered seizure of several factories to ensure continued production, without authorization of any law. Meanwhile, in Congress, a bill was introduced authorizing government seizure of plants essential to war production. It was defeated. Most congressmen criticized the president, especially for not using the Taft-Hartley Act. An impeachment resolution was introduced, but defeated. Then came a bombshell. In federal district court, Judge David Pine declared the seizure unconstitutional and therefore null and void. At once, the steelworkers went on strike and began to leave the mills. In circuit court, the government desperately sought a stay of Judge Pine's ruling and prepared a prompt appeal to the United States Supreme Court. At the same time, the White House continued efforts to settle the wage dispute. On May 2nd, representatives of the companies and the union were requested to come to the White House to continue discussions. Once more, the president asked the union to call off the strike. Once more, it did. In the White House, spokesmen for the two sides began private talks. The nation waited. Perhaps these talks were doomed before they started. As they began, word came that the United States Supreme Court had agreed to give the case an early hearing, meanwhile barring any changes in wages. At this news, compromise became unlikely. Now the scene shifted to the United States Supreme Court. Its ruling came on June 2nd. By a 6-3 decision, it ruled the seizure unconstitutional. A minority of 3 justices felt the emergency justified the president's action. A majority of 6 felt it did not, and said the president had usurped the legislative function of Congress. Thus, the court, in effect, played the role of political umpire. Promptly, 600,000 workers resumed their strike. As time went on, there were warnings. Shipments to our allies were being delayed. Secretary of State Dean Acheson warned that our commitments under mutual defense treaties were endangered. Then, the Secretary of Defense, Robert Leavitt, issued a statement.
And in this great responsibility, I ask the help and support of every American.
He said the strike had hurt defense production more than any enemy bombing raid could have done. Now at last agreement was reached, on terms not very different from those recommended by the Wage Board 3 months before. The men received an immediate raise of 16 cents an hour, plus fringe benefits and a modified union shop. The companies received from the government an increase of $5.20 per ton on the approved price of steel.
We can now get on with the job of supplying steel for the country's urgent needs.
What do these events tell us about the powers of the president and its limits? In each of our great wars, Congress has been more than willing to let the president assume the leadership, and the Supreme Court has not wished to interfere. But as the emergency lessened, the Congress has always wished to reassert itself. This happened after Lincoln in the impeachment of Andrew Johnson. It happened after Wilson in the normalcy of Warren Harding. It happened after Franklin D. Roosevelt in the whittling down of Harry Truman. In the end, much depended on the word emergency. Was it an emergency or was it not? The nation knew there was a war, but its preoccupations were those of peace. There was a tense baseball season, and television was on the rise, with new distractions, new products, and news of peace talks in Korea. The sense of crisis that was so much with us in the Second World War seemed to be missing. All this may have contributed to the defeat of Harry S. Truman in the steel seizure case.
Good afternoon, Chief Justice Rehnquist. On behalf of everyone assembled at Duquesne University in Pittsburgh, as well as the Harry S. Truman Presidential Museum and Library that's co-sponsoring this event, I'd like to thank you for participating in this special program. I have just a few questions to set the stage as we begin this retrospective, looking back 50 years in history. You were just a 27-year-old law clerk, clerking for Justice Jackson, only a few months in Washington at the time the steel seizure case landed in the courts. At the time, was this a case everyone expected would be a constitutional landmark? What was the atmosphere surrounding it?
The atmosphere, so far as one living in Washington was concerned, was very much that it would. The law clerks talked about it at lunch, and it wasn't just the Supreme Court arguments in the case that received press coverage. The arguments before Judge Pine in the district court were front-page news in the Washington papers, perhaps not elsewhere.
And did you and your fellow law clerks have any prediction what would be the final outcome when it worked its way through the Supreme Court?
Oh, I don't think most of us knew what position our justices would take. We did have a vote at lunch one day, and I think, as I recall, we were evenly divided. But that was not on the basis of what we thought our justices would do, because most of us didn't know.
And what do you remember most vividly about the oral argument? I believe it was May 12th of 1952.
Well, the fact that John W. Davis argued for over an hour and I think was asked only one question. I mean, he had a style of advocacy that you don't hear nowadays, but it was very impressive. And then Solicitor General Perlman got a whole bunch of questions from the court.
And Arthur Goldberg participated as well?
Yes, he participated in oral argument for the AFL-CIO, I believe.
Right, for the steelworkers, yes. And in your book on the Supreme Court, you tell a wonderful story about the Justices' Conference that Friday, at which they voted on the case in private. What do you remember about that?
Well, as I say, of course, the clerks weren't present at the conference, but George Niebank, my co-clerk, and I were just as dying to find out what happened, as I suspect all the other clerks were too. So we followed Justice Jackson into his office when he got back, just as we always did, and he would tell us what happened at conference. And he said, "Well, boys, the president got licked."
And Justice Jackson's concurring opinion in the steel seizure case is generally regarded by constitutional scholars as the most significant. What did he say about presidential powers, and why did he write separately?
Well, I think he wrote separately because almost everybody did write separately. I think the opinions had to be prepared in a fairly short time, and I think even those who agreed with Justice Black's outcome felt that there needed to be more said about the thing. And Justice Jackson's concurring opinion classified presidential power in three different ways. First, where he was acting with the approval of Congress, and there Jackson said, only if the whole government is disabled does he lose. Second, where he's acting without congressional authorization, but without congressional disapproval, and there it's kind of a middle ground. And finally, what Jackson felt had happened in the steel seizure case, where he was acting in an area where Congress said, don't do what you want to do something else. And there he said the power is at its nadir.
Right. And did public opinion, do you think, influence the court's ultimate decision that President Truman had exceeded his constitutional power?
I think it did. The government made some extraordinary claims at the very beginning in the district court that the president had all the authority that George III had unless it was taken from him by the Constitution. Well, you can imagine the press outcry about this. I mean, it just made headlines. And it just gave a negative aspect. The government abandoned that argument long before it got to the Supreme Court, but it just got the government off on the wrong foot.
And there was an ambivalence about the Korean War even at that point, wasn't there?
Very much so. There were people fighting and dying in Korea, but very few sacrifices called for on the home front. World War II, I'm not that old. World War II, you had 14 million people under arms, but a lot of things restricted on the home front. The Korean War, you just didn't have those restrictions on the home front, so there was just a real ambivalence, as you say.
Yes. And what would you say is the lasting significance of the steel seizure case as we look back in constitutional history 50 years?
Well, I think the subsequent opinions of the court have adopted Justice Jackson's concurrence, and that kind of trifurcation is probably its contribution. I think people have expressed the view that had it come up in time of declared war, it might have come out differently. And so, it's just one of many cases in this area, but I think the Jackson concurrence has been pretty much what it stood for.
And I'm reminded that one of the great things about a retrospective like this is it allows us to learn history from key people who actually participated in it. So your recollections are particularly relevant and meaningful, and it puts us in a good position now to step back a half century and examine a presidential decision that's really largely been lost to history books and law books, but is still highly relevant. So thank you very much, Chief Justice Rehnquist, for introducing today's program.
It's been a pleasure to be here, Professor Gormley.
Thank you very much. Newspapers were carrying cartoons that depicted Truman commandeering private businesses everywhere as a payback to unions for supporting him in the 1948 election. And so many Americans were outraged by this conduct. What prompted Truman to go that far? Was it bad legal advice from White House advisors? Was it just a rash, impulsive judgment? Those who were close to President Truman at the time, at least those to whom I spoke, dispute that it was that simple to explain. Milton Cale, at the time, was a young special assistant in the White House, and one of the people writing memos to Truman spelling out his options, and he dug out for me this memo that he wrote to President Truman that specifically warned him that if he seized the steel mills and the matter got into the courts, that Truman was not going to have a constitutional leg to stand on. But, so he was acutely aware of this danger, but he consciously took the actions he took in spite of that danger. He was, by all accounts, deeply worried about the threat to troops in Korea. This wasn't a fake, it wasn't a smokescreen. Harry Truman truly was very concerned about that. He was meeting daily with his Secretary of Defense, Robert Lovett, and key advisors in the Defense Department, and all of them were making a firm case that, and showing statistics that there was a serious threat to American troops if the steel mills went idle. Virtually every person in the White House who I interviewed talked about how dead seriously President Truman took this threat. And don't forget, those of you who love history, that Harry Truman had been a captain in the Army himself. He knew that public opinion polls were against him on this, but he used to say to his advisors, what would Moses have done if he had taken a poll before handing down the Ten Commandments? That was his favorite line. Ken Heckler, who was another White House advisor, went on to be a congressman and secretary of the state of West Virginia, told me that Truman really had developed a very elaborate, consistent theory of presidential power from his own study of history. As you know, Truman loved history, and this theory came into play when he ordered the dropping of the bombs in Japan to end World War II, when he fired General MacArthur, when he sent troops into Korea. That theory was, don't wait for Congress to act during times of emergency. If you do that, you will render the presidency impotent and jeopardize the nation. So Truman's plan here was very simple. He was going to seize those steel mills, force the steel companies and labor to sit down at the bargaining table, and then muscle them into a compromise. Then along came the Supreme Court, something he didn't count on. They jumped in with lightning speed and accepted the case under the caption Youngstown Sheet and Tube Company versus Sawyer. And from that point forward, President Truman never stood a chance. The Truman Justice Department, as you saw a little bit on this video, did its best to argue essentially this is wartime. The president can do almost anything that he deems is necessary in a time of emergency. And to do this, it tried to aggregate all of his powers contained in Article 2 of the Constitution, the provision that says the executive power shall be vested in the president, and he shall take care that the laws be faithfully executed, and most importantly, of course, the provision that says that he shall be the commander-in-chief of the Army and Navy. That still didn't sway many of the justices. So we saw it was a 6-3 decision. It was a stinging rebuke of President Truman. Justice Hugo Black wrote for the majority, and he said, in essence, as broad as the president's powers are, even during time of war, and no matter how broadly we try to interpret this notion of the theater of war, where we're fighting the battle, seizing private property at home is simply too much of a stretch. If anything, this is a matter for Congress, because don't forget, Congress is the one that has the power of eminent domain, for instance, and is generally in charge of laws that govern domestic affairs. So, in other words, the bottom line was the Constitution did not give Harry S. Truman the power to keep the country from going to hell by seizing steel mills when he wanted to. The most enduring opinion, as Chief Justice Rehnquist noted, turned out to be the concurrence of Robert Jackson, whose 117th birthday we celebrate here tonight. Jackson was a powerful intellectual. The truth is he didn't care much for the likes of Harry S. Truman, He had headed the trials at Nuremberg. He had been mentioned as a candidate for President of the United States. He was a towering figure in government as Solicitor General and then as Attorney General under FDR. And he wasn't, very honestly, particularly thrilled when Truman passed him up for a poker-playing buddy, Fred Vinson, for Chief Justice of the Supreme Court. But Jackson's opinion is a masterpiece not because of those little personal asides and the personality clashes, but because it went to the heart of the president's power under the Constitution. Many of you have probably heard, if you're interested in Jackson, Professor John Barrett speak, who is really the world's leading, at this point, expert on Robert Jackson. And he explained at the Duquesne program we had that Jackson already had formulated some pretty strong views about presidential power at this time. He had struggled with the issue as Attorney General when he supported President Roosevelt's seizing of the North American aviation plant during World War II. There were a lot of private properties seized during World War II, mainly in that case because it was an exclusive government producer. And so it was almost the equivalent of a branch of the Pentagon, you could think of it today. But in this case, Justice Jackson eloquently laid out this spectrum, 3 different shades of presidential power that exist in our constitutional system, and that is the legacy of the Steele seizure case. In the first category, Chief Justice Rehnquist kind of explained it quickly, but let me just explain because it is important. In the first category, Jackson said, when the president acts pursuant to express or implied authority of Congress, his powers are the strongest because he's acting at that point based on whatever powers he has under the Constitution as president, plus whatever power Congress is giving him, is delegating him. Second category is where the president acts where Congress has neither granted nor withheld power to him. He's in this middle ground. At that point, he's relying on his powers under the Constitution, and there's what the court called the zone of twilight, where Congress and the president can both act and their powers can overlap. In the third category, though, it's where the president acts in a manner incompatible with the express or implied will of Congress. That's where his power is at lowest ebb, because all he can rely on is whatever powers he has minus the Constitution's powers of Congress. And so here, the equilibrium of our system of government, of separation of powers, is at stake. And so at that point, he's at low ebb, and the courts have to be extremely leery with him in that danger zone. And so in this case, in the Steele seizure case, the court concluded that President Truman was in that third weakest category because the Constitution didn't expressly or even implicitly give him power to seize private property even during war. Private property, let me emphasize, on U.S. soil. This isn't private property. This isn't property in Korea. This is on U.S. soil. And not only that, Congress expressly had withheld that power because during debates on the Taft-Hartley Act in 1947, they considered an amendment that would have allowed the president to seize businesses in time of emergency, and they specifically rejected that. So Harry S. Truman was acting contrary to what Congress had said was permissible. Only his closest friends, Chief Justice Vinson and also Justices Reed and Minton, who he also appointed, voted in favor of the president. And make no mistake about it, the court's decision in Youngstown was a stunning blow for Truman in the waning days and weeks of his presidency. Ken Heckler told me, he said, you could see blue smoke coming out of the White House for weeks. And in fact, there's a story, and actually this did happen. There was a dinner party held shortly after that at Justice Black's house to try to make peace. And they invited the president, all the justices, including Justice Jackson, were there. And Harry Truman apparently lit into them during this dinner. No one knows exactly what he said, but we do know that at the end of the dinner, he turned to Justice Black and he said, I don't like your law, but your bourbon's pretty good. So why is it that the Supreme Court had said that the president had overstepped his constitutional boundaries? And perhaps even more importantly, as far as you sitting here tonight, what's the relevance of this today in 2009? Why would we even care? On the first question, I think that's the easy one. It boils down to the simple point that Chief Justice Rehnquist made in that video. By the time this case got to the Supreme Court, there really wasn't a sense in this country that we were at risk. Fighting in Korea had come to a lull. People in the United States were more worried about this battle between the New York Yankees and the Brooklyn Dodgers that summer than they were about this steel seizure issue. And so there was a sense that these dire military warnings by Secretary Lovett and others were just very much overblown. And in fact, they were overblown because the plants were idle for months and there was no interruption in production of steel during that time. So the military warnings in hindsight probably were highly exaggerated. But here's the key thing I want you to understand. The steel seizure case isn't about good versus bad. It isn't about moral absolutes. It's about the very difficult process that a nation like ours has to go through during times of crisis, struggling with how much latitude we give a president as commander-in-chief, how much power we have to reserve for Congress, and then the court's role in this tricky balancing act. The steel seizure case, I have to tell you, and Justice Jackson's three-part test in his concurrence, has lurked in the shadows of every president since President Harry S. Truman. It was cited prominently by the Supreme Court when it ordered President Nixon to hand over the Watergate tapes in United States versus Nixon. It was a key case in deciding that President Ronald Reagan had the power to freeze assets in the United States and set up this special claims tribunal to deal with claims against Iran after the Iran hostage crisis that many of you remember. It was even cited in Clinton versus Jones in deciding that a president could be sued civilly while in office. The steel seizure case has always been there, kind of like a length of cord wrapped around the president's wrists, ready to tighten around his hands and around the entire executive branch that answers to the president. But this only happens if the courts, and ultimately if the American people, determine that he has stepped across that very fine constitutional line. So now, as to the second question, how do the steel seizure case and the lessons of Harry S. Truman in 1952 and Justice Jackson's concurrence, how does any of this have any application to our lives today? In 2006, I had the privilege of testifying in the United States Senate on a major issue involving presidential power. And many of you will remember this. It was in, kind of around this time of year in 2006. The White House had just publicly acknowledged that in the wake of the September 11th attacks, President Bush had authorized the National Security Agency, or NSA, to institute a program to monitor and intercept communications between persons like us on U.S. soil and other people abroad, presumably in an effort to pierce this Al-Qaeda network that we had just discovered was so expansive. And according to the Justice Department white paper that was issued in January of 2006, these domestic wiretaps, and I want to emphasize they're domestic, they're on American soil, usually involving American citizens, these wiretaps and interceptions carried out by NSA without warrants, ordinarily required by the Fourth Amendment, were being carried on at just an expansive rate. No one knew about it. The Bush administration policy also circumvented this elaborate mechanism that had been set up in the 1978 law of Congress called the Foreign Intelligence Surveillance Act, otherwise known as FISA. And by this, Congress had set up a special court pursuant to its powers under the Constitution to handle precisely these kinds of emergency requests from the executive branch. In testimony before the Senate, then Attorney General Gonzalez defended the Bush administration's practice by insisting that this was vital to national defense. And President Bush himself told the nation that as Commander-in-Chief, he had to possess the power to fight our enemies wherever they were, however he saw fit, even if it involved this kind of gathering up of information on American soil. I never, unlike some of the other folks who testified, I never questioned the good faith of our President or our Attorney General. These were certainly unusual times in our nation's history, and they remain unusual times. There's no doubt that the President's power as Commander-in-Chief, even on American soil, was potentially heightened, at least for a period of time, given these attacks at the World Trade Center and then the continued threat of attacks by this totally new brand of enemy. So this was admittedly a new set of rules. Our nation was faced with this shifting paradigm in which our own soil, and of course that's when we set up the Department of Homeland Security and everything else, the Patriot Act was passed, our own soil arguably had become part of the field of battle. This, combined with previously unimagined new forms of technology and communications technology especially, I think probably did ratchet up presidential power generally on the home front. At the same time, think about it for a second. The defense that was offered by the Bush administration for its wiretap program was eerily similar to the losing argument advanced by Harry S. Truman in 1952 when he seized those steel mills. Because even aggregating all the powers available to Truman at the time, available to him under the Constitution, the Supreme Court had concluded that keeping the country from going to hell, even during a time of war, was not sufficient grounds to just nullify the Constitution. Seizing property on American soil was generally reserved again to Congress under the Fifth Amendment and other provisions. So, as Justice Jackson went on to say in his concurrence so eloquently, presidential power was at its high point in this theater of war. Presidential power, the president's power, is at its high point on the field of battle in foreign lands. It's at its lowest ebb on American turf, especially when the president has acted without congressional or constitutional support. So applying these lessons to the Bush wiretap program, I argued that the Bush administration's gathering up of phone calls and emails bumped up against the Constitution in a number of ways and failed to survive that collision. It's problematic enough when the executive branch does an end run around Congress and bypasses this legislative scheme that was specifically put in place for just this type of domestic surveillance, the FISA law. But the problems only multiply tenfold in a situation like this, where the chief executive actions collide with fundamental rights of citizens and with U.S. residents under the Bill of Rights, specifically in this case under the Fourth Amendment that requires a neutral and detached magistrate to give a warrant, usually. In such a case, the president's power is at rock bottom. In fact, it arguably falls, and I argued this to Senator Specter and others, it arguably falls in a category even lower than President Truman in the steel seizure case, because we now have these individual rights that are potentially being lost. There's no question, ladies and gentlemen, that President Truman believed passionately in 1952 that his actions were necessary to protect American troops, to protect soldiers in Korea, to safeguard the nation. There's no question in my mind that President George W. Bush believed fervently that the warrantless surveillance of certain communications by citizens or residents in the United States was necessary to carry out his administration's daunting war on terror. Yet, as Senator Specter aptly stated during the give and take of the hearings, this doesn't provide a blank check to any president. Congress and the courts, in fact, have a duty to correct the situation, have a duty to step in and stop the president if the executive branch commits an error in assessing its own powers. It may be true that in the immediate aftermath of the aggression of 9/11, the president's powers take on a real heightened importance, even on in America on the domestic front. But unless we're prepared to say that a president can just suspend the Constitution by making a unilateral decision that there is some kind of an emergency, unless we're prepared to say that, we cannot permit a president to make those kinds of decisions by himself or herself. And there is nothing weak or activist at all about the other branches of government stepping in to stop it. In fact, that's what we call checks and balances. That's what we have. Our entire system of our rule of law depends upon that, and our country collapses if we don't have that. So at some point, I believe, a president who seeks to enhance his powers in that way has to do one of two things. He either has to go back and get authorization from Congress, assuming Congress has the power in the first place to give it to him, or he has to convince the people themselves to amend the Constitution and give them the power. In the case of the secret Bush wiretap program, Congress wrangled with this issue for literally 2 years, and it eventually rewrote the FISA law to give the Bush administration most of what it wanted, and then the Protect America Act was passed in 2007 that now allows the government to intercept phone calls, emails from Americans on U.S. soil going out of the country without warrants in certain cases. So that significantly broadens this law that we call FISA. But pay attention to the fact that at least this was done now with congressional approval, and this time the courts are involved. Under the original plan of the Bush plan, and that's what troubled me so much as a constitutional lawyer, the courts weren't involved at all. It never got to the Supreme Court. There was no one who even had standing to challenge this. Now the system is working properly. Now Congress sets up a system, it goes through the FISA courts, it's very generous to the administration, but ultimately the final check rests with the United States Supreme Court. And in fact, right now, and this is the system working correctly, there are a handful of cases in federal courts around the country challenging provisions of this new legislation. Similarly, as you're doubtless aware, the Supreme Court has correctly invoked Justice Jackson's concurrence in the Steele seizure case, his test there, to strike down a number of efforts by the Bush administration in recent years that have sought to deal with enemies, captured enemies, in the name of exercising presidential power. So in the Hamdi v. Rumsfeld case in 2004, and then later in Hamdan versus Rumsfeld in 2006, the U.S. Supreme Court, and I must say, including a number of justices who generally were supportive of President Bush's policies, sharply limited the scope of executive power to detain and try suspected terrorists as enemy combatants, especially, and this was what those cases dealt with, especially when those enemy combatants happened to be U.S. citizens, one of whom was captured in Afghanistan originally, but U.S. citizens being held on U.S. soil, or we've heard a lot about it, in Guantanamo, in the brigs in Guantanamo Bay. Justice Sandra Day O'Connor, again in Hamdi, emphasized that even something as dire as the events of 9/11 and everything that came from it do not give any president of either party a blank check. And so just this past June, in a landmark case called Boumediene versus Bush, the court went even further and held that foreign or alien terrorism suspects, these aren't even American citizens now, held at Guantanamo Bay had a right to challenge their detention in the United States under the Constitution. Another curtailment of presidential power. What we've learned from experience is that times of crisis are usually when we make the worst decisions. in hindsight. And that's true not just in America, but in any country. In America, the fear of communists and socialists during the First and Second World Wars led to prosecutions under the Espionage Act, and in hindsight really drastically, improperly curtailed First Amendment freedoms. Attorney General Palmer's roundup and arrest of thousands of suspects in 1919 and 1920 during World War I who were allegedly part of a communist plot to overthrow the government, which never panned out, was viewed later as a disgrace. Many of you are very familiar with the panic after the Japanese invasion of Pearl Harbor that led to the internment of 100,000 American citizens. These were American citizens of Japanese descent on the West Coast, moved to these camps in the middle of the country. And the infamous Korematsu case that I think the Jackson Center also did a program on, that was later vilified, and the Solicitor General of the United States publicly apologized and remunerations were paid to those families. So times of crisis are when we make the biggest mistakes. On the other hand, there are real reasons for doing these things. President Lincoln was criticized repeatedly for suspending writs of habeas corpus during the Civil War, arguably in violation of the Constitution. And he would say, well, I'm not sure what good this Constitution is going to be for us if we don't have a country anymore. The fascinating thing, I think, ladies and gentlemen, about being alive at a time like this, it's a complex, fascinating, complex, admittedly dangerous time in our country's history, is that we get a direct view into the minds of public servants, great public servants like Robert H. Jackson, who have taken steps to prevent overreaching during times of crisis for the sake of preserving this democracy. Our fear of terrorism in the United States today may prove to be accurate, it may prove to be greatly exaggerated, and we aren't going to know for probably quite a long time until the web of history is finally woven. But without remaining true to our to the dictates of our Constitution, we can be certain that we will lose more than we'll gain. One of the great things about having the privilege of lecturing in a setting like this to celebrate the life of a great American jurist born here in Warren County over a century ago is that we still are in the midst of a debate on this subject. And the beautiful part, as far as I'm concerned, is that ultimately, in another 5 years, 10 years, 20 years, as a result of thoughtful public discourse, including gatherings like this, as a result of that, the courts and Congress and our presidents will figure out among themselves how much power is appropriately wielded by each branch and to what extent each may have crossed over the line in dealing with the aftermath of the events of 9/11 in a way that prevents and actually threatens the long-term stability of our democratic experiment. So it isn't all black and white, just like Justice Jackson's test. It's all grays. And Justice Robert Jackson, with brilliant foresight, taught us how to make sense of this blurry spectrum when it comes to presidential power. He also taught us, I think, ultimately, that it isn't the president or Congress or even the Supreme Court of the United States that will ultimately decide how far each branch of government can go in a great democracy like ours. Rather, ultimately, it is us as citizens who will make that call. Thank you so much for the privilege of being here in this beautiful courthouse with you tonight. I'm happy to answer questions. Yes, Judge.
When Congress took up the challenges of FISA, NSA wiretapping, were they able to legislate with any real understanding what the president was doing, or was the scope of the wiretapping hidden from public view?
Yeah, that's a great question, Judge. I think at first, Congress did not know what was going on, and the Bush administration's position at the time I was standing there testifying was you know, this is all top secret, you don't get to know this. It was funny, the evolution of it, and you can appreciate this, all of you who are judges here tonight. Congress, during those hearings, was most interested in making sure Congress got to figure out what was going on. And so it was decided pretty early on in the game that you know, a joint committee of foreign intelligence of the, you know, House and the Senate would be involved and get briefed regularly. And my message was almost pathetically simple. I just kept saying, make sure the courts are involved. Make sure the courts are involved. And I can tell you, the most surprising thing to me is a lot of people in that room, and certainly a number of people from, key people from the Bush administration, did not seem to understand to me the role, the basic role of the courts in the system. Because to me, it was just patently unconstitutional to have any system that ultimately didn't get funneled to the judicial branch and the Supreme Court. And the system they started constructing wasn't going to, no one would ever know what Congress and the NSA were talking about, so no one would ever have standing to bring a lawsuit, and there would never be a case. That is why I am pleased with the ultimate result, because we can tinker with it, some of it may be unconstitutional, but all three branches of government are involved, which is appropriate. And that was not how I believe the Bush administration envisioned it, and they fought that for a long time. Yes?
How does standing come up in the new cases? Because every case to date has been turned aside on the question of standing.
Yeah, very honestly, I haven't followed that carefully enough. I mean, obviously, there are some cases in the hopper right now, but apparently some of these, somehow, some of the folks who are the subject of these wiretaps have figured that out, and I'm not sure how that's the case. But once you have a live person like that, or a company or whatever, a U.S. citizen who's being tapped, or they're gathering up information, then you have a plaintiff, presumably. But it's still going through the secret FISA court. Yes, sir?
Does the Supreme Court get involved in the continuation of the Iraq War? Thinking of 05 and 06, the public was quite for pulling out of Iraq. Was the Supreme Court involved in that controversy?
Well, not directly, because there's no case. It really gets back to the same question. There's a whole issue standing, for those of you who aren't lawyers, has to do with who is the right person, if any, to bring the lawsuit. So some cases don't even get to the courts. And then there's a related issue that deals with political questions that says that certain matters are left to other branches of government. So generally, Congress doesn't have standing, for instance, to just challenge a piece of legislation or challenge what the president is doing. So it's very difficult to even get a case into the Supreme Court dealing with these issues having to do with the war. I think that what the Supreme Court did primarily was nibble around the edges with these cases that I mentioned, having to do with enemy combatants, having to do with Guantanamo. And again, you know, this is a court that right now is 5-4, is generally viewed to be 5-4 more conservative than liberal. But that court still, a majority of that court still found that the Bush administration had overstepped its bounds in that department. Yes, sir.
Can you elaborate at all on if, you know, it's on the news or whatever, with respect to potential war crimes or anything like that? Can a U.S. president be held to some standard that he's grossly misapplying the Constitution?
Well, I thought, Greg told me I was going to get easy questions about Monica and Paula Jones and things like that. Let me just say, and actually, you know, Greg's the expert on Nuremberg, so maybe we have to talk to him later. But I can tell you this. For instance, there was a lawsuit in Texas right before the end of the Bush administration, trying to sue Vice President Cheney and others for various, you know, crimes having to do with Iraq and other things. And my position consistently on these things is that first of all, I think it's very difficult to ever prove something like that. And second of all, I don't think it's productive to go down that path. I really don't. I mean, we have differences, political differences, as to whether a president made a correct decision in terms of some of these things. But I get some of these emails with people who are trying to get you to sign on for a lawsuit to charge the president with war crimes or whatever, and I just delete them whenever they come across. But I really do think, I was serious when I said that I took the president at his word. I believe that President Bush really did have grave concerns about threats to our country. And I think we have to get back to basic respect for public officials, whether or not we're of the same party, whether or not we agree with those positions, and worry about the law and fine-tuning that. So I do not think, I mean, I think that some of this stuff will come out, for instance, having to do with weapons of mass destruction as some of the documents ultimately are released over time, and we may find out some of this wasn't especially pretty. I think history is the proper punishment if mistakes were made in that department, and I don't think it's productive for a country to start bringing those kinds of suits. Yes, in the back, ma'am.
I have a couple of questions. Does the executive split powers the parameters for executive privilege? If it's not, what precedent, who set the precedent for it? Number one. And if the president, if the United States of America is the aggressor and start the war, since there were no, the United Nations went there for 8 months, it searched the country and found nothing. But we went there after Mr. Blitzer found that there were no weapons of mass destruction. We had no business to be there. And supposedly the quote-unquote criminal was in Afghanistan, which makes Iraq sort of the wrong country. And why didn't anybody in the Supreme Court challenge President Bush's, why not challenge him to prove that there was a reason to be there?
Okay, let me try to answer quickly those three questions.
Thousands of innocent people over there.
Right.
You mentioned Americans.
Let me try to answer quickly. First of all, executive privilege, what we're referring to is that the Constitution impliedly provides a privilege to presidents acting in an official capacity. The landmark case dealing with that, of course, was United States versus Nixon, that said that there is such a thing as executive privilege, but in that case, because there was an ongoing criminal investigation, that privilege was trumped by the need for evidence, in that case the Watergate tapes, for a very specific purpose. But assuming you're referring to the breadth of executive privilege for instance, President Bush, Vice President Cheney, any of the folks in the Bush administration, that relates to my answer to the second two parts of your question. I guess all I can say is this, and I don't pretend to be an expert in some of these areas like international law or anything like that, but think back to that Justice Jackson's test for a minute, because I didn't emphasize this part that much yet. In his test, Truman was at the lowest point, and I think President Bush was at the low point having to do with the warrantless wiretap, because they were acting on U.S. soil in territory that the Constitution generally gives most authority to Congress, okay? Conversely, there's a whole line of cases, U.S. v. Curtis Wright and other cases like that going back to the 1930s, that say that the president is at his high point when he is dealing with foreign affairs. So I just want to start by telling you that, without getting into all of the debate about the WMDs and all of that I'm not qualified to talk about, I don't see that a case like that, it goes back to this gentleman's question, is going anywhere unless, I mean, if there's just shocking evidence that comes up, then maybe at some point it crosses the line. But the president, as the person under the Constitution who is in charge of foreign affairs, who appoints ambassadors to foreign countries, who is the unitary head of the branch of government to deal with other countries, is going to have every deference paid to him when he's dealing with matters of foreign affairs like that. So I just don't see it, frankly. Likewise, with respect to the Supreme Court, let me just go back to the point made earlier to this gentleman. The Supreme Court doesn't just take cases and say, you know what, let's rule on today whether President Bush did something improper in attacking Iraq when there really wasn't enough evidence of that. That's not their job. Their job is to decide cases or controversies under Article 3 of the Constitution. And so it's only if there is a ripe case that brings it to them. And, you know, the cases that deal with the president's power as commander-in-chief, don't forget also, let me remind you, that the president took that action with specific authorization of Congress. Now, maybe, you know, the members of Congress can say, well, if we knew today what we, you know, if we knew then what we knew today. But the fact is, I want to come back to this point that when we're in the middle of a crisis, we do things that sometimes aren't that great, but there's no other way to protect ourselves, very honestly. And rather than leaping to condemn people, I think our time is better spent correcting the problem and moving on and dealing productively with all of these other things that we face in the world rather than looking backward. So I guess that's my 2 cents worth, is that the flip side of what happened to Harry Truman is that when a president is operating overseas in foreign affairs, especially in the matter of war, and he's commander-in-chief, he's up here in terms of his power. It's going to be very, very difficult to ever bring him down from there. Yes, sir.
In the Steel Seizure case is cited today that primarily Jackson concurrence cited. Can you talk a bit about a three-part test? Was it a novel conception? Was it consistent with precedent or something new?
That's a good point. Yes, typically the Steel Seizure case is synonymous with Justice Jackson's test today. Every once in a while you may hear some reference to Justice Black's opinion, but Justice Jackson's test is, in all the cases I've talked about, U.S. v. Nixon and Clinton v. Jones, it's always Jackson J concurring that we're talking about. And as to the novelty, that's a great question. I don't really know. I've never looked at that. I only can assume it was, because there was no clear-cut precedent at the time with respect to presidential power. And in fact, there was conflicting anecdotal evidence, because there were a lot of examples of FDR during the Second World War seizing coal mines, we talked about the aviation plant, and Jackson argued a couple of those as Solicitor General. So it was a tough call, but to my knowledge, this is the first case that squarely brought that issue to the court, and that's why it's so important today. And incidentally, I was kind of chuckling when I was watching that video again, because you notice at the one point I asked Chief Justice Rehnquist if public opinion had anything to do with the court's decision, and he said, yeah, I think it did. When I had mailed a copy of that before my testimony to Senator Specter, who had invited me to testify, and he, kindly introduced me to the Judiciary Committee, and he said, and I just watched that video last night, Professor Gormley, and you got the Chief Justice to admit that public opinion influenced the decision. That's the first time in my life I've ever heard that. But it was highly unusual. The whole situation was highly unusual. And Chief Justice Rehnquist has written a book about, important moments in American history where he talks about some of that stuff. But it is, as I said, the granddaddy of the cases still dealing with presidential power.
Is
Yes.
Is that video you have available?
For $2,000, no, I'm just kidding.
I feel a connection because my daughter works for U.S. Steel, safety manager. My grandchildren lived in Homestead, and I saw the sign for Homestead down there.
Yeah.
And my dad worked for the steel mills in Butler, Pennsylvania.
Oh, is that right? I stole it from the Truman Library. I did edit it myself, but you know, if you want to talk to me afterwards, myself or Greg can probably make a copy of it if you'd like to just see it. But you know, I can't disseminate it in any way. But to my knowledge, there is no other film like this, and it was not being used at the Truman Library. They had it on one of those old, you know, big, it was a newsreel film. I'm sure many of you used to watch them. And they pulled it out, no one had watched it, and we were able to digitize it and then produce that. Yes?
You talked about the presidential emergency powers and then I'll refer to military situations. But what about economic situations? For example, if banks never lend any of the money that Congress has given them, at what point can the president act and force them, even if the Senate never gets their 60th Democratic vote to shut off the debate?
That's a great question. Did everyone hear? At what point could President Obama, for instance, if there was, you know, this economic crisis, and you know, that's fascinating because that's kind of a new version of 9/11. It's another potentially devastating event that doesn't have to do with terrorists flying planes into buildings, but has to do with the economy. All I can tell you is there might be some moment when it got so severe and so threatening to the well-being of the country that the president could act alone. It would take a lot because this is just so directly in the domain of Congress that I think that it would be overstepping the president's bounds. He can lobby, he can advocate legislation, but for him to just do something, I think would be unconstitutional. But let me add...
Roosevelt seized the bank.
Yeah, let me add that caveat that just because something's unconstitutional doesn't mean a president can't do it. And that's what Harry Truman's point was. There are certain times where a president makes a decision recognizing that he really doesn't have the power, but if it's going to prevent the country from collapsing, he's going to do it anyway, like Abraham Lincoln did during the Civil War. And then maybe the Supreme Court will tell him he violated the Constitution, and maybe he'll take a drubbing, as Harry Truman did. But that's part of the decision of being a president. And ultimately, what you do is you hope that you carry it long enough that Congress does get involved and steps in and does what is right. So that's a great question. And again, there may be that extreme moment when he can do it, but for the most part, I think he'd be exceeding his powers. Yes, John.
Last time I promised. I want to focus in on the law schools and the American bar. One of the questions that boiled the courts was a declaration that the Geneva Convention didn't apply. And later there was a determination that Common Article 3 did apply to anybody that was brought to Guantanamo. But between the presidential declaration and the Supreme Court decision, you see that the American Bar Association, the American judiciary, and the law schools lived up to their responsibility to bring that debate to the public forum. I mean, your point here tonight, Justice Rehnquist's point, is that we're all engaged in a public conversation about the law, and that we matter when we raise our voices. So would you look at our performance there and give us your perspective?
Well, I can only speak from my limited perspective. I did finish a stint just last year as president of the Bar Association, as Greg mentioned, in Allegheny County. As part of that, I got to go to, ABA conferences and all this. my sense was there was a lot of discussion about this. I mean, there were the ABA and various bar associations were speaking out about Guantanamo, about, you know, the ABA, and Justice Kennedy, incidentally, has become a great advocate of the way we convince the rest of the world to become more like us, to become democratic, is by example, not by threats and power. And so my sense is, Judge, that there really has been an effort to get that dialogue going in a big way. And certainly, in fact, you know, it's funny, the first time I spoke on this topic was, it must have been 2002. It was not long after September 11th, and it was at Chautauqua. And I remember talking about, and many of you may remember at that time, it was almost considered un-American to suggest that the government was doing anything wrong. And I remember being heartened by the fact that so many folks at Chautauqua had questions about, well, why can the president do this? Because that's when the Patriot Act was starting, and we were starting to hear about all of the possible constitutional violations involved in that. And all I can tell you is that I actually watched that evolution where we went from just a group at Chautauqua kind of quietly whispering about, weren't some of these things problems under our system of government, to that prevailing in the United States. So I guess I'm more positive in terms of looking back on these things and thinking that the public has greatly shaped the debate on them. I kind of will end with the point, we have to return to respect for public officials, respect for the government, because this is us. And you know, when we get into these battles where we start just spending our time warring with each other, other things are happening that aren't necessarily good and productive. But thank you so much for your time this evening. It's been
Professor Gormley, we say thank you very much. And until you have a chance to read your own book here in January, we do have a couple of books for you. This is an autograph book on Robert Jackson by Eugene Gerhardt, which he signed shortly before he died. He signed a few of those, and we'd like to present that to you. Similarly, Gail Jarrow signed a book for you as well, and we just want to thank you because you've raised the bar a little bit higher here at the Robert H. Jackson Lecture, and on behalf of Warren County and on behalf of the Robert Jackson Center, we can't thank you enough. We look forward to reading your book. Thank you so much, Mike.